I'm just so delighted that my friend, the amazing Martha Jones, has come to speak about her award-winning book, Birthright Citizens, A History of Race and Rights in Antebellum America, which came out in 2018. Professor Jones is the Society of Black Alumni Presidential Professor and a professor at history at the Johns Hopkins University. She holds degrees from Columbia and CUNY, I know we have some CUNY people, and was actually a public interest litigator before she went back to follow her dream of being a historian. She's a legal and cultural historian whose work examines how Black Americans have shaped the story of American democracy. And in addition to this book, she is also the author of All Bound Up Together, The Woman Question in African American Public Culture, a co-editor of Towards an Intellectual History of Black Women, and has a forthcoming book, Vanguard, A History of African American Women's Politics. And Professor Jones writes frequently for broader publics at the Washington Post, the Atlantic, the Chronicle of Higher Education, and Time, and she's a member of the OAH Historians Executive Board, president of the Berkshire Conference of Women's Historian, and a frequent participant in my own society, the American Society for Legal History. Last year, Laurel Davis and I did an exhibit and wrote a forthcoming article on the library and intellectual life of the great Robert Morris, the African-American antebellum civil rights lawyer and activist. And one of the books that Morris had in his library was the book that opens Professor Jones's book, William Yates's Rights of Colored Men to Suffrage, Citizenship, and Trial by Jury. From the moment when Professor Jones begins her discussion in her book of this William Yates and another William Yates, she pulls the reader into her narrative. It's a narrative characterized by meticulous historical research and remarkable retracings and rediscoveries of the voices of Black Americans, insisting on their rights and their right to inclusion. I am in awe of the careful construction that underlies the architecture of the book, each chapter opening with an individual's voice, each chapter focusing on a different piece of paper that inscribed, constrained, or included Black Americans. I clerked in Baltimore and fell in love with the city. It was the city of Frederick Douglass and Thurgood Marshall, and as Professor Jones thinks about in her epilogue and her next project, a biography, also the city of Roger Taney, author of the Dred Scott Opinion. And it's a testament to Professor Jones's extraordinary skills as a historian, understanding how the present is still haunted by the past, that she ends her book musing about the ghosts of Roger Taney in the courthouse presided over by Judge Wanda Hurd, herself the descendants of slaves. So I couldn't think of a better speaker today for Constitution Day, so I'm happy to introduce you to Professor Jones. She's going to speak for a while, take questions, and we will end at 1 so people who have classes can get to them on time. Thanks.
Good afternoon. Well, I want to thank Mary Builder for a very generous introduction because Mary is the legal historian I aspire to be. And so let there be no mistake about how things are organized in this room today. But I'm very honored, and I want to echo the thanks that she offered to everybody, the Clough Center, the law school, Keelan, who's somewhere making sure all the trains run on time. It's really an honor to be with you all today. It won't surprise you when I begin by saying that when it comes to birthright citizenship, we live in troubled times. This began with alacrity and robustness in the summer of 2018. First, White House operatives, later that fall, the president himself, followed by the new United States Attorney General in good form, we learned that in high places, the rights, the privileges, the status of birthright citizenship is very much up for debate today. And it has led to some, I think, curious but also provocative targetings of people who we might once have thought were indeed birthright citizens in some unassailable sense. Pundits doubted whether Kamala Harris, the daughter of unnaturalized immigrants born in Oakland, California, people really mused out loud. Harris might not be a natural-born U.S. citizen and hence entitled to hold the office of the president. William Barr, during his confirmation hearings for U.S. Attorney General, when asked about birthright citizenship, said he had no views. Wow, no views at all. But really, I think more to the spirit of my talk today, in our midst, border officials are questioning the veracity of birth certificates held by U.S. citizens, detaining them for weeks. New rules narrow birthrights reach, no longer guaranteeing that the children born to U.S. military and diplomatic service members overseas are citizens by birth. Our friends, our classmates, our neighbors, ourselves, we carry reams of documents and a lawyer's phone number when we travel, even domestically or locally, wary that we might be the next citizen whose right to remain in the U.S. will be questioned. We don't have to, it turns out, imagine a nation in which people live without the protections that birthright accords. We don't have to imagine it because in our not too distant history was a period during which, without birthright, a community of Americans were subjected to a sort of persistent terror, not unlike that which we see unfolding around us today. The history of how we got to birthright, the story I will tell you this afternoon, is a window into our own times. Before the Civil War, before emancipation, before the 14th Amendment set birthright into our Constitution, free Black Americans, many of them formerly enslaved people, lived at risk, subject to political whims and without clear recourse to when some Americans declared that this nation was a white man's republic, one without a future for Black people. They faced persistent threats of removal or deportation in today's parlance, and lawmakers failed them, failed to settle the law, to set the law, to define their relationship to the Constitution, leaving Black Americans to fend for themselves, and then, I think remarkably, to become the architects of a new Constitution that bequeathed to us all that bedrock that is birthright. It's a hard history, but I hope it's also an inspiring one when we learn how Black Americans struggled against their exclusion, their erasure, their near expulsion from the U.S. to insist upon their right to belong, to remain, to come and go, and to be Americans. Start here, a marker in Baltimore's Laurel Cemetery, a historically African-American cemetery that now sits just north and west of the city in Johnstown. This is the marker of a gentleman named George Hackett, who's going to be our guide for our time together today. Why Hackett? The arc of his life, he was born in 1807 and dies in 1870, really parallels the story that I'll share about the struggle over birthright citizenship. He was born free in Baltimore City, but he was born in the era just after African-American men had been disenfranchised in the state of Maryland. The word white was inserted in the Constitution, and he lives nearly long enough, just shy of the moment when the 15th Amendment is ratified, if you will, restoring political rights to Black men in the U.S. And the thrust of Hackett's vision is that, as Martin Delany, his peer, the abolitionist, minister, activist, journalist, wrote, "We are Americans having a birthright citizenship. Our common country is the U.S. Here we were born, here raised and educated. Here are the scenes of childhood, the pleasant associations of our school-going days. the loved enjoyments of our domestic and fireside relations, and the sacred graves of our departed fathers and mothers. We are Americans by virtue of having a birthright citizenship, natural claims upon the country, claims common to all others of our fellow citizens, natural rights, which may by unjust laws be obstructed, but never can be annulled. Constitutions. So I've gotten ahead of myself just a little bit with Martin Delany. Because many decades before, as early as the 1820s, men like George Hackett are facing a profound question. Who are they before the law? Who are they before the Constitution? And they begin to look, to examine, to study this question in their own vernacular ways. And they begin, indeed, with the text of constitutions. George's first education comes at home. His father is an activist, building institutions like the African Methodist Episcopal Church. His father is responsible for publishing the first of the African American church law in the United States. He is an agent for Freedom's Journal, the first of the African American published newspapers in the U.S., beginning in 1827, where men like the Hacketts will study law, debate law, develop their ideas, not through formal training, but in the pages of their own newspapers. Charles Hackett is a remarkable activist, and he offers to his son an education, both formal, informal, in these early years. And they study the Constitution. They scrutinize its language, trying to discern where they might fit in. You all know, I don't need to tell you, that the original Constitution of 1787 is nearly silent about citizenship in any substantive way. It uses categories like enslaved people, free people, and Indians. It talks about the privileges and immunities of citizenship, but it does not tell us who is a citizen. There is that little invoked, at least until this moment, little invoked requirement that the president be a natural-born citizen. And it is on this particular clause that Black Americans seize and begin, just to begin, to build a theory about who they might be. If the president is a natural-born citizen, there must be such a category provided for in this Constitution. And furthermore, they don't see a color line in this document. And so why are they, too, not citizens of the United States? They look at state constitutions, in my case, the state of Maryland, which is even more so silent about citizenship. And this leaves room both for doubt about where Black Americans stand, but also room for building a case. Why citizenship? It's a good question. There are two pressures that are bearing down on men like the Hacketts in a city like Baltimore, but really across the U.S. in this period. Free African Americans are the target of a political movement called colonization. Colonization has intellectual roots in the 18th century, but by the 19th century it's taken institutional form in that of the American Colonization Society. Colonizationists at their core believe slavery will end. Might be years, it might be decades, it might be a century, but slavery will end. And when it does, there's no place at all for free people of color in the nation's body politic. Colonizationists organize, they raise funds, they outfit ships, they found colonies like Liberia, and their plan is to remove former slaves from the country. And this is a tremendous pressure on men like the Hacketts, who are resolute about Baltimore and the United States as their home. They also face pressures from Black laws. These are usually state-level statutes that regulate the everyday lives of former slaves. Where can you work? What sort of work can you do? Can you own property? Can you trade in staple goods? Can you own a gun, a dog? Can you travel in and out of the state? How can you worship and under what conditions? Black laws regulate the quotidian existence of former slaves, and what these folks come to recognize is that, in fact, Black laws are a sort of companion to colonization. They are intended to make life in the United States so untenable, so uncomfortable, so difficult that people will succumb, will give in to the enticements of colonization and, in essence, self-deport. So while men like the Hacketts are debating this in political conventions, in their newspapers, in all likelihood at the kitchen table, boy, I'd love to be a fly on the wall in those moments, It turns out that highly placed lawmakers are asking very much the same questions. One example from 1821 is the debate over the admission of Missouri as a new state. Missouri presents to Congress the text of a new constitution, and it provocatively includes a provision that says no free person of color may enter the state of Missouri at all. A blanket prohibition. And Congress members, well, they pause. Is that constitutional? Is this a violation of the Privileges and Immunities Clause? Can you draw a distinction between black and white people for the purposes of then regulating the in-migration into a state like Missouri? Well, it turns out it depends on whether or not you conclude that free people of color are citizens of the United States. And as we examine the annals of the annals of Congress, many, many pages and over many, many days, both in the House and the Senate, we see that there is a robust, learned, and very, very vexed debate that unfolds in 1821 over this question. So vexed, in fact, that at the end, Congress can't figure it out, and they do a curious thing. They admit Missouri, and they let this provocative provision in the Constitution to stand, and they admonish Missouri. Now, law students in the room, you'll tell me what it means when Congress admonishes. I'm not sure what. But it is evidence, for this admonition is evidence that the debate, right, is unresolved. It is sustained even out of this moment. The admonishment is that the state of Missouri should never violate the constitutional rights of any citizen, including citizens of color. It's a sort of punt, right? It's a fudge. And this is the murky state of affairs that I want you to appreciate the free people of color inhabit in all of these decades that take us to the Civil War. Lawmakers who deliberate, who appreciate the complexities and the stakes of the question, and who nonetheless punt, fumble, lots of sports metaphors here, and don't get it, right? Don't get it right, however they might come down. So here, this is the world in which George comes of age. By the late 1820s, George is married, and he's begun a family. He's working as a waiter. He's an entrepreneur, begins operating a livery stable. We can begin to glimpse his sort of budding ambition and drive. He also experiences setbacks. His stable is washed out by a flood. Many of his horses are killed, and he has to fold up the business. His firstborn child, a son, a namesake, George, dies in infancy. It's a difficult time in his family. And Hackett does what many free men of color do from Maine to Charleston in this period. He goes to sea. He joins the crew of the USS Constitution. And my Boston people, I don't have to tell you what that is, do I? I had the privilege last spring, finally, of a visit to the Constitution to see where Hackett spent many, many months between 1838 and 1841. He joins as the steward to the Commodore, so he sits right at the seat of power as the fleet heads out on a Pacific tour. And even before they come around the Horn of South America, Hackett is getting a sort of comparative lesson in the question of who are free people of color before the law, because it turns out that there's nothing unique about that question in a city like Baltimore. Every port city in the Americas is being animated by the uneven end of slavery, the discerned emergence of free communities of color, and this question, who are these people with respect to the body politic? Who are they before the law? They stop in the free independent city of Veracruz in Mexico, in the thriving sugar colony of Cuba, in the port of Havana. They spend many weeks in Rio de Janeiro, the capital of the Brazilian Empire, and an active slave trading port even in the 1830s. Here, free people of color are everywhere presenting and provoking a set of challenges, asserting rights, being rebuffed, being incorporated. And we can begin to see how life at sea for a man of color like Hackett with a set of questions is a sort of education, the study of comparative law, I might suggest. Seamen like Hackett, however, do more than simply study. They themselves provoke questions. Before he would have left out of the port of Norfolk in 1838, Hackett, like most of the sailors aboard the Constitution, would have secured what was called a Seaman's Protection Certificate. This is a formal document issued by customs officials that is evidence of the U.S. citizenship of sailors, intended to protect them against forced impressment by foreign powers at sea or in foreign ports. This document that evidences that Hackett is a citizen, but contrast this to what happens when men like Hackett find themselves in a port like Charleston, where port laws determine that free men of color are not permitted to enter the city of Charleston. Either they must remain sequestered aboard ship while their port is in the city's harbor, or they must disembark and spend their time in jail. Is this constitutional? Well, it depends, doesn't it, on whether or not you think these men are citizens. Again, law putting men like Hackett in an unresolved, murky at best, dangerous at worst set of conditions. Now, the last thing about a naval flotilla is the thing I learned when I spent time with the logbooks of the Constitution. Then when one is stationed in the Commodore quarters, it turns out that one has a ringside seat when the ship becomes a courthouse. It won't surprise you that all along the many, many months of this tour, sailors commit a really interesting range of infractions. Many of them during the short periods when they are at liberty in port cities. And tribunals are convened, lawyers are appointed, juries are established. And Hackett has a ringside seat for this. And he observes two things that I think are especially germane to his thinking and his rethinking about who he might be or could be before the law. The first is that in the Navy, black sailors can testify against the interests of whites, and it happens often on the Constitution. In Baltimore City, those black laws would prohibit this. Black men can't testify against the interests of whites. The second thing he observes is that white sailors, as well as black, when they are convicted of an offense, they will likely be flogged. Now, back in Baltimore, flogging or whipping is a punishment reserved, in the worst sense, for people of color only. It is too close to the culture and practice of slavery, such that white men are excused. They are punished, but not with the lash. And I think, again, in this way, Hackett has a close-up view on another sort of legal culture, one that extends to men like him some simple but powerful rights that might take them somewhere in the courthouse. Now, the Commodore dies tragically and unexpectedly on the west coast of South America. Hackett's time is finished, and he hops a whaler, the Anne, which is out of Nantucket, to make his way back to the U.S. And he disembarks in Nantucket in 1841, and he literally steps into the hotbed culture of radical anti-slavery. Not 2 weeks before, another black Baltimorean, Frederick Douglass, has given his very first anti-slavery speech right there in Nantucket. I don't know what George does when he disembarks, but I know that everywhere he would have stepped, he would have encountered the echoes of Douglass and the spirit of this anti-slavery culture. And then he does a remarkable thing, or at least remarkable to me, is that he comes back home to Baltimore. Rather than make his way and realize his aspirations in New England, he heads back to his home city and becomes first one of the very rare black property owners, purchasing a small home and a lot. His family thrives. There's a beautiful description of his eldest daughter's wedding, and it is a sort of modest but clearly has the flavor of a society affair in Baltimore City. He follows in his father's footsteps and becomes a deacon in the AME church and will go on to be a powerful leader there. So wasn't he a citizen? Well, how might he go about making the case? Well, the first thing that Hackett does brings him here, and this is the Baltimore City Courthouse of the 19th century. Here, those of you who know Baltimore, the Battle Monument is sitting right here. It's just off our shoulder, behind the camera. He winds up in this place because he's gotten into a kind of dust-up on the streets with a white man, John Pitt. Pitt has, I'm not sure, he's assaulted Hackett, is what Hackett charges. But what's most interesting for us is what Hackett does. And what Hackett does is take himself into this courthouse, swear out a complaint, show up at the trial, testify against Pitt, and before it's done, he goes home with $1 in his pocket, the fine. But I want you to hear the way, even in this simple proceeding, he is pressing against the prescriptions out of the state capitol in Annapolis, which would say he cannot testify against the interests of a white man. Well, it turns out in Baltimore City that he can. He is a leader, as I mentioned, the AME Church, and we find him in this courthouse again and again, protecting the property of his congregation and others like it. Predatory lenders, speculators target free African Americans in Baltimore and their modest property holdings, especially their church buildings. And Hackett becomes savvy about this, but once again, asserting himself, developing a kind of legal acumen, hiring the right kinds of lawyers who will permit him and his congregation to testify against the interests of white creditors and speculators and to defend this literal brick and mortar manifestation of their claim to belonging in this place. Now, this is happening in Baltimore, and rest assured that lawmakers are observing the way in which people like Hackett are carrying themselves, as one commentator puts it, like people who have rights. And this is, at best, provocative, if not perceived as dangerous in Maryland. And lawmakers convene in a large and 18-month law constitutional convention in 1850. It is the first wholesale rewriting of the Constitution in Maryland since 1776. What animates the Constitution? The convention, many things, including a commitment to settling, establishing, fixing the status of people like Hackett. Everybody knows it's an open question and a troubling question for many white Marylanders. There's a debate. I bet you know where this is going. Maybe they're denizens, maybe they're aliens, freemen, citizens, maybe they're just human beings. A committee is formed and 3 resolutions are proposed, all of which would carefully fix and regulate and demean the status of free people of color. They're never voted on. And in the end, this Constitution, after 18 months, includes one, I think, really flaccid line, if you will, that says, we empower the legislature to figure it out. It is a punt, right? It is this kind of incapacity to act, to resolve, to fix this question that is characteristic of Hackett's life and the life of his community. Now, maybe when you saw the title to my talk, you thought I was going to begin with that notorious Supreme Court decision, Dred Scott, so let me get to it. 1857, Roger Brooke Tawney, a Baltimorean, a man very much knowing about what is happening in the everyday life of his hometown of Baltimore, resolves, opines, that free people of color, along with enslaved people, no black person can be a citizen of the United States. For a long time, I think we thought Tawney had the definitive word, or the last word. But it turns out, first and foremost, Tawney is deeply frustrated because nary a federal court will actually follow to the letter his intention in Dred Scott, and trial courts will slice and dice and distinguish the facts and continue to permit free men of color, not very many, but those that come into the federal courts, to sustain their suits. But the real rebuke comes the next year in 1858 in a case titled Hughes versus Jackson, which is before the state high court in Maryland, its Court of Appeals in Annapolis. Hughes and Jackson are two free men of color. One has sued the other because, it is said, one has kidnapped and is holding as slaves the children of the other. Samuel Jackson, whose children have been detained, wins at trial, not only custody of his children, but $750. And Hughes takes it to the Court of Appeals. And he makes, by way of his lawyer, and you know how lawyers do, he makes an interesting argument that might sound against the interest, the long-term interest of his client, but serves the immediate interest of trying to wrangle out of this fine. The argument goes that Maryland, like the U.S. Supreme Court, should adopt the deep logic of Dred Scott and regard free people of color as those without rights. Jackson's suit should be dismissed, like Dred Scott's suit was dismissed. And hence, of course, Hughes would be excused from the fine. And interestingly, at least for me, when I first read this case, the Court of Appeals says, no thank you. No thank you to the logic of Dred Scott. No thank you to a world in which free people of color have no rights. No thank you to a world in which they cannot sue and be sued. Now, rest assured, or I hate to disappoint you if you were hopeful that sitting on the Court of Appeals in Maryland were men who were, I don't know, nascent radical Republicans or abolitionists in secret or civil rights activists just waiting to break out. No. They are acting from a set of self-interests, two of them in particular. The court reasons, first and foremost, there are 75,000 free people of color in this state, and the vast majority of them are workers. They are an engine of prosperity in Maryland. And what man would work for wages if he didn't have the ability to come into a courthouse and protect the fruits of his labor? One. Two, those 75,000 people, if we deem them without any rights whatsoever, will be transformed in one gesture into outlaws. Right? People who will continue to live among us, to have disputes, to have claims, but now, without recourse to the courthouse, their disputes will play out in our streets, in our alleyways, on our byways. This is not a prescription for prosperity, for social order, for the well-being of the state of Maryland, including for white Marylanders. And so we are going to guarantee to free people of color the right to sue and be sued in our courts. Now, the last time I find Hackett in the local courthouse, it's 1859. He's insolvent. And again, this is another example of the ways in which he's able to testify against white creditors, secure the forgiveness of his debts, weave himself into the local economy to sue and be sued as the Court of Appeals has promised to him. In 1859, John Brown's raid on Harper's Ferry really jolts the political and legal culture of Maryland and of all the American South. And in Baltimore, Hackett gets whiff of new proposed legislation that would, in essence, either re-enslave or forcibly exile free people of color, all 75,000 from the state. He steps away from this courthouse strategy and begins to organize circulating petitions, collecting signatures. He takes himself to Annapolis, confronts the lawmaker who's proposing this legislation. Politics, lobbying is what we call it today, against this legislation, and remarkably, he succeeds. And when he explains what he's done, he says, I speak on behalf of the 75,000. I speak as a person with rights under the Constitution that this legislation would deny, would run roughshod over, to remove us from the state without cause and without recourse. The legislation is defeated. And remarkably, the same legislation in this moment succeeds in the state of Virginia. So I want to finish up by talking about this moment of the Civil War and Reconstruction. Hackett will continue in his own local and vernacular but powerful way, even before we get to a Civil Rights Act of 1866 or the 14th Amendment. Hackett will be busy in Baltimore City making the case that he is a citizen. We find him heading the first of the free black militias in Maryland, something that had been strongly prohibited before the Civil War. We find him effectively lobbying for the establishment of public schools for black children. He'd been paying taxes for decades without any access to the public schools. We find him a member of the Republican Party, on the cutting edge of insisting upon the voting rights of free black men in Maryland, beginning in 1864, years before we get to the 15th Amendment. I like to think that Hackett didn't wait at all for lawmakers in Washington, except that he waited for them to catch up with him because he was busy showing what it meant to be a citizen. He doesn't live long enough to be a part of this remarkable scene, which is the celebration of ratification of the 15th Amendment, the national celebration, which takes place in 1870 in Baltimore City. This is the very same courthouse square that I showed you earlier, in the shadows of that courthouse where Hackett had plugged away at this insistence that he was a rights-bearing person, that he was a citizen. Now this national celebration is unfolding. And if you're at all a little bit like me and you believe that people do indeed watch down on us, I'm sure you agree that Hackett would be here with a deep sense of satisfaction, not only in the accomplishment of the 15th Amendment, but that the celebration would take place here on his own home turf. So with that, I'll stop and thank you all very much. Thanks very much.
You can see why she's the person I aspire to be. So Martha, with her perfect timing, has left plenty of time for questions, and I'm going to let her call on people herself.
Absolutely. Questions, comments? And someone has to break the ice. It's okay, I'm a teacher, I'm patient. You know that little rule, you're supposed to count to 10 backwards, and by the time you get there, someone will have a question. Thank you. Well, had I more time, I'd be delighted to talk about the 14th Amendment, because, of course, this long building of an argument about birthright citizenship runs through Hackett, but through all of African American political culture through these decades. I highly recommend the forthcoming book from Christopher Bonner, which is, I believe, called Remaking the Republic, which is a long study of African American politics, mostly in the North, that looks precisely at this debate about citizenship. But it is an important one because what we know from the work of other colleagues is that by and large, legal commentators, treatise writers do not generally take up the question of citizenship in this period. It really emanates out of these debates, and by the time we get to 1862, it is when Attorney General Bates issues an opinion that affirms the citizenship of free people of color during the war. Bates is pulling on all those arguments that had been built up in the antebellum decades and now consolidating them into this powerful Attorney General opinion that then will get reflected in the Civil Rights Act and in the 14th Amendment. So I hope that is at least a little bit of a primer about how we get there. Sure. Thank you. Hi.
Hi, I was so interested to hear about the formulations of citizenship as participating in legal processes, testifying, not being allowed to be deported. But I wondered how the historical line, and particularly African American input in that line, has knitted in with broader conceptions of social citizenship, considered by T.H. Marshall and others, about what it means to be a fully participating member of
So it won't surprise you, T.H. Marshall is a place that I begin this book, as sort of a formulation and a primer and a way of thinking about this. And frankly, part of what I discover is that a few of the people I write about, few of the people involved in these debates are political philosophers, even amateur ones. These are really arguments in which folks are throwing a lot of things at the wall to see what might stick. These are desperate moments, and we could talk more about sort of what that looks like on the ground as people face this threat of removal. African Americans are keen students of Indian removal and the Trail of Tears. They try and hire the lawyers, William Wirt and John Sargent, Horace Biddle, the folks who have represented the Cherokee. They hope those folks will represent them in their claims to an unassailable belonging. So I don't mean to elide your question. It's to say, yes, that there's a lot of things they throw into the hopper within their own debates, but what sticks is the Constitution. What sticks not only for them, but out in the world. Right? It's the Constitution that is troubling Congress in 1821, even as military service is something they talk a lot about, even as labor and uncompensated labor might undergird a claim. It is the Constitution, and this sneaking suspicion I think that everybody has that actually even the 1787 Constitution implicitly recognizes citizenship is bestowed at birth. This is where they get traction, and this is what they invest in, not to be indifferent to other ways of thinking about belonging and the rights and privileges of belonging, but they are, I think, without a doubt, understand that what some people have called territorial citizenship, right, the right to remain, this is what's really the origin point for the kinds of arguments they then build. So thank you for that. Hi.
intersecting modes of citizenship that are taking place at this time. I'm thinking about how the first Naturalization Act of 1790 is limited to 3 white people.
Yep.
And I'm thinking about modes of gaining citizenship through parentage, which is very problematic for interracial couples or people who are coming from Haiti or Senator Mingo. And I think all these things are kind of in a stew in this particular moment. And you talk, I think, wonderfully about the birthright aspect of it. But some people refer to those things as involving certain birthrights. And there's a complexity there that I was wondering if you had any thoughts.
Yeah, thank you for that. I hope it comes through that this book and the research for me is centered on this local courthouse that I showed you. So my answer will come out of that because one of the more sort of provocative and arresting scenes that I found in the criminal court docket very early on in the research went like this. Free men of color are subject to black laws, which means in order to own and possess firearms, they must come in annually to secure a permit. And they do. They secure 3 respectable white people's signatures, they appear before a judge and state their purpose, and they are granted a permit to keep a gun in Baltimore City, a city where everybody else has a gun too, they just don't need a permit in this period. And remarkably, in the same court session, in the same afternoon, I find immigrants, mostly German immigrants, appearing before the same judge in the same courtroom, because I'm sure you know, but I did not, that naturalization in this period begins in a state courthouse. It's not the exclusive purview of the federal administration at all. And so alongside these men who are securing their guns are other men who are renouncing, right? They're renouncing allegiances formally. And all this is happening on the eve of Election Day. And it is an extraordinary snapshot into, for me, into the various ways in which different men are entering into political culture. German immigrants by renouncing allegiances and now being made eligible to vote. African American men who are carrying firearms and yes to hunt, yes for self-defense. But in Baltimore City, there is no more essential instrument of politics, be it get out the vote or suppress the vote, than a firearm in this period. So I think that scene sort of tells us that these are really companion stories, but free men of color enter the problem or the possibility of citizenship and belonging with a very different set of possibilities, and they use these black laws, in my interpretation, in order to firm up and shore up their belonging, much in the ways in which immigrants are using this formal renunciation to do something that is quite akin. So I hope that's helpful. Thank you. Mary Builder.
So I was just wondering if you can talk a little bit about what your thoughts are on how it matters how we tell the narrative of the United States in this country. And I think I completely agree with you with the story of disenfranchisement in the 19th century. And I know a lot of our students have read the 1619 Project, which is also an effort at retelling who belongs here, who the story of the nation is about. And I just wonder if you can talk a little bit about that.
Yeah, sure. And thanks for that. You know, the next chapter of this story, it's one I have written about in articles, but don't look for it in the book because it's not there. And frankly, I was still thinking about this as I finished the book. You know, the next chapter of the story is the ways in which the prospects for Black Americans and, say, Chinese Americans diverge in the period after the Civil War, that this birthright citizenship, which sticks for Black Americans by and large after 1868, does not stick for Chinese Americans. And it will take us all the way to the end of the century and Wong Kim Ark for Chinese Americans to be excused, if you will, from a reign of terror to which they were subjected many decades after African Americans were, by and large, excused not from many things, but certainly from the prospect of exile or deportation or refusal at the border. So I think that it is a reminder. In one part, it is a reflection on the 1619 Project, as powerful as it is, that, and frankly, that the narrative of Black Americans is not the whole story and can't stand in for the whole story of one about national belonging, because there are important divergences that go back to Reconstruction. So I think that's important. You know, there are folks who are assailing birthright, you know, from, as we say, from the right, for lack of more nuanced language, from the right, but also from the left, right? Birthright is is a conservative and blunt and incomplete instrument of national belonging. But I would say that for me, it's very difficult to imagine this country without birthright. Because part of what we know is that racism and xenophobia infect every other quarter and corner of American law, and arbitrates, right, rights and privileges throughout until here we sit. Except birthright. You know, that in every generation there are the despised, right? There are the despised, and Black Americans, we might claim that we are the eternally despised, but we recognize that if not before, certainly after September of 2001, Muslim Americans are the despised, and still their children are citizens of the United States unassailably. In the early 20th century, you know, the children of radical communist thinkers and doers are citizens of the United States. And that is a powerful bulwark against, in my view, the role that xenophobia, racism, and more could otherwise be playing in our scheme of national belonging. So I don't think the past is a blueprint, and I don't think it's enough to invoke this past in order to defend birthright today. But I do think this story goes some distance to helping us appreciate the work that Birthright does, even in our own time, incomplete and imperfect as it is, will help us better debate and confront that question, because it is here. And we need to be able to defend it in our own language, in our own time, and for our own purposes, and not simply as some carryover from a remote past. So I'm not sure I answered your question at all, but you gave me the opening to say some of the things I wanted to say.